Hey guys, it's Wendy again. This is me again following up with fixing some of my earlier YouTubes by adding narration because I didn't know what I was doing in the beginning. And of course you want narration so you don't have to just like sit and read the screen. Okay, here goes. This is the timeline of HOA boards contradicting documents on the path regarding construction of pathways through commons, court islands, construction, 57 park benches, and more signs. All right, this is version 2.0. And this is a timeline of the HOA board's documents and actions pertaining to the impending path and seating construction in the commons and on the court islands. There's 10 documents total that we're going to be looking at. Most can be reviewed quickly, but a few are unnecessarily complicated answers from the board to simple questions, so they require a little bit more time to decipher. These documents will be shown in chronological order, starting with the 4/23/22 annual meeting minutes. Those are the meeting minutes from last year. Most of these documents, as well as other documents pertaining to pretty much everything, can be viewed on my website, hawthornhillstransparency.org. You do not need a password for it. Okay, and here we go. The 4/23/22 meeting minutes is 3 pages long and contains quite a lot of detail, but makes no mention of a plan to pause pathway construction until the lights are corrected. It's important to see all of the following document to see that that statement is not there. So here are those meeting minutes in their entirety. And I've highlighted all that was said about the path plans. You'll see the only mention of paths is landscape design completed. Okay, there's the top of it. And there's the middle of it. And there's the bottom of it. And there's another YouTube I made that compared my documents to the board's documents posted on their very own website. The only difference is mine has my highlighting on it. So before you start saying I've made this all up, you know, take that into account. And let's see, here it is. Landscape design completed by Miller Landscape for the entire neighborhood. Drawings are available to view after the meeting. They put up on, they had big blown up pictures of blueprints of all of the plans. But that's all they said about it. They're on hold until we fix the light color. Nothing like that. There's the rest of it. I'm not going to read the whole minutes to you. Oh, this is where a resident motioned to explore an external management company for the HOA. It was seconded and approved. That comes up later. Okay, now the judge's holding on May 25th, 2022 is very important. The holding is, the court having found the plaintiff's claims were not moot based on the plaintiff's argument that a trail improvement project is currently pending and for other reasons stated on the record. That is all of the legal holding the judge wrote down, okay? He didn't write this long law-creating statement that tends to keep being read at us. I don't know where the president is getting that. He was not in attendance at the Zoomed hearing, but several other residents and I were, and all he said right before the ruling was, well, if it's payments are over 12 months, then it's maintenance. That's it, which was ridiculous and silly, and it still seems that way. But I'd like to see where they're saying the judge ruled this blah, 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 blah long law statement that he has, because it's not there. The only thing the court did say specifically was, hey, it's not moot based on the plaintiff's argument that a trail improvement project is currently pending. So that's a big, hey, stop that, you know, this is separate. And basically here I've just said the same thing. Okay, somewhere along the way, Judge O'Brien misunderstood there to already be trails and that the path project the HOA president was considering was one of improvement, not new installations. It does not follow that brand new streetlight installation where there were none before should be categorized as maintenance, but improving trails that he thought were already there should not be categorized as maintenance. I would ask Judge O'Brien that to his face if I had some way to talk to him. I'd want to understand how one was maintenance and one wasn't, and they should be flipped anyway. Okay, however, lower court judges, and I do give him some credit for how busy they are taxed with hearing oral arguments and on processing up to 40 or more cases scheduled in a single day. Although of consequence, it is a tedious small detail and was not highlighted in the arguments. That detail being that the paths they would have been brand new, not improvements on paths already built. Again, court having found the plaintiff's claims were not moot based on the plaintiff's argument that a trail improvement project is currently pending and for other reasons stated on the record. The judge said the lighting issue isn't moot because of the trail project. I would put this in here. I can't hear the word moot without thinking of the scene from Friends when Joe is saying this is all a moot point. It's like a cow's opinion. It doesn't matter. It's moo. Okay, so Joey thought a moot point was a moot point, and since it was a cow's opinion, it didn't matter. In addition to being close to the everyday meaning, he's close to the legal meaning. Yay, Joey. Moot is when a judge writes it, means that he or the court won't consider an issue again. That's all finished. It won't resurface. It's all done. So here Judge O'Brien was going out of his way to limit his holding to the lighting issue only, saying he explicitly excluded extending the ruling to cover the trail improvement project. He did not want the president to take this ruling as a permission slip to run wild on the trails. Unfortunately, that seems to be exactly what he did. Instead of acknowledging, the judge specifically recognized that the path installation project is different, so should not be executed the same as the lights. The board has done the opposite. The board has specifically pursued it the same way they did the lights. The board acted as though the court held the issue was moot. But the court said the issue was not moot, specifically given the very path project that they are doing now is the reason why. In fact, Judge O'Brien limits his holding to the lighting even more when he goes on to say, and for other reasons stated on the record. It's moot, not just because of the president's path plans, but for other reasons stated on the record. Sorry, it's a moot point. Not moot. Okay, May 31st, 2022, we have an email from the vice president of the HOA. Okay, this gets into the conflicting information that we are blamed for. On 5/31, our HOA vice president responded to a resident who expressed concerns about clearing behind their home. He said there were no active plans currently to install the walking paths. If everyone knew that the plans were merely on pause while the lights were corrected because it was stated at the annual meeting, this could not have been a truthful statement. Again, after the annual meeting, where in December they said, in the annual meeting we said they were just going to be on pause until the lights were fixed. When he said there were no active plans currently to install walking paths, that could not have been truthful. One of those statements has to be false. Obviously, when a plan has a pause as a step in it, that planned pause is part of the active and current larger plan. Note the careful use of verb tenses that appear to be an attempt at a responsibility dodge. He says both active and currently literally just one word apart. This strained and careful wording will come up again. Here is that email. There he is. There's highlighted. First and foremost, there are no active plans currently to install walking paths anywhere in our subdivision. This email, again, is so full of red herrings and partial truths that it is too much to address every single one of them here. This video is already going to be too long. Here I will address just a few of them. Please remember this poor resident just asked whether all the new severe clearing was for the paths. This resident is not an attorney. It should not require an attorney to decipher the answer to a direct question asked of a board member. Come on. Our VP said he has no active plans currently. Our VP said his no active plans currently was his first and foremost point, but only got to it after 2 paragraphs, one of which was something about something that wasn't even asked. In his second paragraph, the vice president referred to a resident to the DNR document and the bylaws, noting that in the event of a conflict, the DNR is control. Here's that. In the event of any conflict arising between the bylaws and the Declaration of Restrictions, the terms of such declarations of restrictions shall be deemed to be controlling. Unless it was meant to be confusing or obscuring, it is unclear why it would reference the bylaws provision on conflicts without specifically identifying the conflict that actually exists. He didn't identify what the conflict was. Maybe because there wasn't one. He just said, this bylaw says if there's a conflict, the DNRs win. Again, didn't say what the conflict was. How confusing is this? But if the board believes there's a conflict with the bylaws, they should identify it for the benefit of residents so that we can be aware that a particular provision of the bylaws is not controlling and we'll all know what the rule is. If not, then the provision is irrelevant to the resident's concern and only serves to deflect attention from the resident's concern. Again, which was, is all the new severe clearing behind my house for the paths? He goes on to state that the HOA is responsible for maintaining the common areas. There it is. The association is responsible for maintaining the common areas. Okay. No one disputes this, so why was that stated, except for to confuse the issue? Was the board conflating new development with maintenance? The resident understood our vice president's direct statement of there are no active plans currently to install walking paths anywhere in our subdivision. Okay, that's a clear statement. But he responded to seek clarification on all the other things that our vice president added in. The resident received no response. June 17th, 2022, there was a clearing of nature. On June 17th, a large amount of raising of growth took place. An alarmed resident sent me this photo of what was left of what had been a healthy tree the day before, and shared this video of the freshly shorn area. It was all filled up with nature before that. The exact word that they said was a devastating, they were devastated. Devastating amount. The cutting extended the present clearings way up closer to the residents' property lines than they'd ever experienced before, and didn't seem to pertain to any sort of drainage issue. Later on July 21st, when there was another shearing down of nature, that ground crew personally told me that the June 16th clearing was ordered by the HOA. It was the same work crew on both days. The resident that sent me the photos and video confirmed that the landscaping employees there had a discussion about the HOA removal order on June 16th with the president of the HOA. On June 16th, the resident called the city official that regulates tree removal. He came to the site and joined in the conversation between the president of our HOA and K&S Tree Service June 16th. There was never any pretext whatsoever between any of the parties on June 16th that the cutting was ordered and paid for by any party other than the HOA. July 5th, 2022, email from the HOA VP. Great, another one. On July 5th, our HOA VP responded to a number of residents who had received an email alerting them to the severe shearing down of nature for paths currently taking place at the hands of the board. Here's that. Let's address this email one bit at a time. It's pretty long, again, complicated unnecessarily. He stated there had been no major tree removal by the HOA. But this tree was cut down June 16th on orders from the HOA and appears to have a trunk that is 6 inches in diameter, thus it would be classified as a major tree. He was not aware of any removal other than that of dead or threatening trees. I'm not aware of any tree removal. There it is highlighted. Note the ambiguity here. Other tree removal could have occurred even if he wasn't aware of it, and or the HOA could have authorized minor tree removal, again, which we now know is any sort of growth that is 6 inches or less in diameter. His email did not explain his distinction between major and minor trees. The definition of major trees is important. We talked about that. The removal process is different. You'll see that distinction is noted but not defined in other documents. This careful threading the needle with the wording is, again, transparent, not in a good way. Permits are supposed to be obtained prior to cutting down trees with a trunk that is suspected to be 6 inches or thicker and greater. 6 inches or thicker in diameter. It's notable that much, if not the majority, of the privacy-enhancing growth found in the beautiful pockets of wildness within the easements were made up of trees with a trunk less than 6 inches of trunk diameter. Brush, vines, tall grass, animal nests, other ecosystem components. The majority is not 6 inches or greater trees, but he's mostly focusing on the trees. Our HOA VP does not address the removal of anything else or of it being cleared. He only says there are no plans to do any clearing of our common areas. There are no plans. This appears to be another painfully obvious leaning on the board's careful use of present tense verbs here are, I'm sorry, this is off the slideshow, but this reminds me of like when, like a 4 or 5-year-old kid, steals a cookie. And the mother says, are you eating a cookie? No, I'm not eating a cookie. Well, because they already ate it. I mean, it's a really immature sort of threading the needle on words that, there are no plans. Well, not only were there actual plans, but the pause was part of the plan. Not fooling anyone. Even if the statement that there had been no clearing ordered by the HOA did not fail, even if it did not fail on its face due to the fact that the June 17th cutting was verified to have been ordered by the HOA by many sources, once again, if the plan, as they come to state December 22nd, had been since at least April 23rd, of 2022 to have path construction on pause until the lights were fixed in tone. Then any pause in the clearing of trees or other growth was always a planned for step in an always overarching plan. It was never canceled. He then implies that the work was done by Consumers Energy, though he does not state that Consumers Energy actually did so. He simply states that Consumers Energy owns the property and can do with its property as it sees fit. It's a dodge. We notice the difference. There it is. Stating this fact about Consumers Energy is stating an assertion that no one contests. But the assertion is irrelevant if Consumers Energy did not actually do the clearing. One wonders what purpose is served by mixing an irrelevant factual statement in with a demonstrably false statement, if not to feed rumors and misinformation. We get emails like this, and we're blamed for confusion. July 21st, 2022, there was more clearing of nature. On that date, it was confirmed to be ordered solely by the HOA by the team lead on the ground. The owner of the tree company, the HOA hired a K&S tree service. The above parties also confirmed that the prior June 17th cutting was done by them and they were hired by the HOA. The K&S lead on the ground gave me the phone number of the person he'd coordinated with for the clearings, who he said was the president. He wasn't. I called that resident to find out why he thought the clearing was being done. Open-ended. Hey, this clearing's happening. What's going on? This fellow resident spoke as though everyone knew they were for the paths when he told me. The resident who's upset only gets one vote of 356 as to the paths. That's just one opinion. We now know there was no vote on this, despite it requiring one. He didn't just get one vote. He got no votes. Nobody got votes on this. If residents want something different, they should go to the meetings. Okay, come on. Stop shaming residents for not going to the meetings. The meetings are not places where you're allowed to talk. It's authoritarianism. It's ridiculous. Again, residents shouldn't have to go to meetings to keep their board members from breaking the bylaws. A survey was taken years ago, and this is what residents wanted. Again, no vote on this. This is a document timeline, so I'm resisting the urge to explain here how much discontent is sown between neighbors when residents are misled into standing on false beliefs about what is required to make such big changes right out from under other residents. No recipe for peace. To say the least, it is extremely divisive and will continue neighbor against neighbor on each project like this as long as people cannot trust that fair rules are being followed. Although the resident was obviously angry, I calmly tried to explain to him that he did not have to take my word for anything. This is the person I talked to on the phone that was angrily telling me that this is what people wanted and that person just got one vote and there was a survey. I calmly tried to explain to him that he did not have to take my word for anything. He didn't have to try to convince me, but he could see all the documents for himself on a website. That made him more mad. He yelled at me that I have no need to go to that website, and then he hung up on me. That's the environment here. That is the civil war that is bred between neighbors when you have a board that not only doesn't follow rules, but apparently tells residents different unfactual things that they're relying on that aren't factual. I would much prefer if we all joined together on a path to peace instead of on these paths that invade the privacy of our neighbors' spaces. Here's the meeting between the president and a resident that took place. And that was at some point between July 21st and August 23rd when the newsletter was sent. A resident met with our HOA president concerned about losing the privacy in his backyard due to these impending installations. First, the president was a no-show, but on another day, our president later did actually show up, keep an appointment with him. And in person, he assured the resident that paths would not be installed, dismissing the plans as just a list of ideas. Well, the lights were also just a list of ideas. I think they got installed. Just a list of ideas. When asked by residents that are against them, the two active board members have tended to say the paths aren't happening, they're just on a list of ideas. List of ideas. We've already paid Miller Landscape for detailed architectural plans that appear to have required quite a lot of land surveying, as they have details down to the angles of residents' driveways perfectly accurate. Although it's safe to assume this extensive work was not free, just like we have no way to verify how much money this board has paid our lawyer with our money to litigate. Well, it's not our money. I mean, it is our money, but it's not our lawyer. The lawyer doesn't represent us. It represents the HOA, which does not represent us. We have no way of knowing how much this board has paid our lawyer with our money to litigate against our own resident who brought suit to enforce the bylaws on the lights. So do we also have no way of varying how much this board has paid Miller Landscape for all the work they've done so far? There are no invoices for anything after the year 2019, and yes, we've asked several of us at different times, not just me. For some reason, the board has given themselves a license to just ignore me, and actually other people I've talked to that have expressed different views from them. But they don't have a right to do that, but they've not provided the invoices to anyone that's asked. If you choose to believe that thousands can be spent towards a project and it's still honestly categorized as just a list of ideas, let me pause there for a moment. At the meeting, Hickson said I was on a campaign of misinformation, but he couldn't say anything factual except for, well, we only paid $2,000 for the plans. I guess this might be where he's finding fault in all of my factual YouTubes. If that's the only thing he can cite, we've done the best we can with all the documents delivered. I don't know that I believe that Miller Landscape has only been paid $2,000 for the plans. I tried to get them out to work on some trees, and they said their minimum to come out was $2,500, but maybe it's just $2,000. Hey, it's not his money. It doesn't matter really, does it? All right. But please take into account that the streetlights were literally on their same loose brainstormed list of ideas. Same piece of paper. One difference is they actually asked for feedback on whether residents wanted the lights. See the July 2020 survey. However, the results were overwhelmingly negative towards them. See the July 2020 survey results. I thought about doing another video to debunk this because, oh my God, it's just repeated over and over. The survey said we wanted lights. No! The survey said the residents don't want the lights. And the committee disbanded after the survey results came back because they were negative. All right. Anyway, they put the lights in anyway. It would be foolish here to assume the board would take into consideration residents' feedback prior to plowing ahead again, this time on the path construction, or even ask for it to begin with. Why would they want to know? They're going to do it anyway. The common use implication of the phrase would be, don't worry, it's not happening. There will be a fair process and plenty of time for residents to choose against it. That is the phrase, just a list of ideas. But even before the December 2022 announcement that the paths were back on, this board had proven they don't believe any step on their part is required between just an idea, and their execution phase. Based on the board's past actions, you should not expect to see any more concrete plans until the concrete is literally being poured. Then it will be too late to stop them. Just a list of ideas gives a false sense of security to residents. Let's see. Okay, August 23rd, 2022, President's Update. I've shown this in the Path Plans video. In the video, the HOA President assured residents he had no plans to install walking plans and said there had been rumors and misinformation spread around. By him, he squarely places the responsibility for any confusion regarding construction outside the board. Ladies and gentlemen, this whole, slideshow is full of board documents, board authored documents. Here's the one in August. The HHHA board has no plans to install any. That was their August statement. Their December statement said it's back on. The reassuring statement was very clear but false. Again, by August 23rd, 2022, the board had literally already bought and paid for plans. So no plans. The board has no plans. They literally had bought and paid for plans. And they were rendered as early as October 2021 based on the blueprint dates. In addition to the actual blueprint plans they had, everyday use of the word, running constantly and securely in place, just as planned since the annual meeting, were the actual path plans. Okay, just a note here, if you're learning of these or any of these updates for the first time, that could be because the board only has an estimated 51% of lots email addresses. If you are a resident and did not get it, you are likely in the group of an estimated 49% of lots that do not get updates because your email is not in their directory. For further details on lack of notice, please see the Transparency Gaps video on the same channel. I haven't made one of those. Well, I made a gaps video. It's more financial. Basically, you know what? I'm going to have to make another video to explain the way that they say they give notice and how that fails. They don't have all the emails of all the residents. The emails that they do have represent about 65, it's about a rate of 65% are individual lots. That is to say, many people that give the board an email address give them multiple email addresses. So for every 100 emails they actually have 65 unique lots represented with those emails. And that's how you look at the number of actual emails in the directory and come to the determination that only about 51% of lots are actually covered. So I hope that made sense. Okay, December 22, 2022 plans uploaded to the website. Okay, these were the links that were posted to the website shortly before the delivery of the December 22nd, 2022 newsletter. They also landscapes. Again, I put this in the path plans. Although it's not indicated by the name of the links, they go to blueprints and renderings, not just plants, not just landscaping. It's like concrete and pavers and things. These plans that are no longer on pause will cut down at least 8 more major trees, install paths up behind residents' property lines and their common areas, place seating in courtyard islands, install 57 park benches. No, not 5, not 7, 57. Install paver seating areas to put them on. Install 9 brown brick entrance signs that have nothing to do with our brand. Install a boardwalk, a gazebo. Install marking signs on each side of each path between the ground and black poles. Install at least 4 landscaping lights. Install a sundial. And more. All of those plans are available on hawthornhillstransparency.org, which does not require a password. I've also renamed the files there, so when you go there, you'll be able to find them easier, so you don't have to open every single one of them to find what you're looking for. I've named them like what they actually are. And there's also, let's see, a YouTube video that shows all of them. I got that, okay. December letter from the board. Here's the last one. I know this is long because there's so many contradicting, communications from the board. I'm sorry, it's long. I'm sorry, the board keeps spitting out so many contradicting things. Okay, the letter said in the last sentence of the 4th paragraph, the 2nd page, as noted in the annual meeting, the plan was to pause on further plans until the street lighting error was corrected. Recall that we scrolled through all of the pages of the 2022 annual meeting minutes at the beginning of this video. There was no note at all that the plans were on pause until the street lighting error was occurred. This last sentence, corrected. This last sentence is the most life-changing message in this letter, but it is so passively written it's very easy to miss. I don't think that's an accident. Once it's found, it requires the reader to ignore all the problems with the lights other than the tone, and there were lots of other problems, and there are lots of other problems with it other than the color, and intuit that the change in light tone is what he meant by the street lighting error. It also requires the reader to be aware of whether all the light colors and all the subdivision lights have been changed, which is an undue burden. Further, the reader would have to keep reading past the sentence earlier in the paragraph that would lead a resident to relax and think the paths were only a starting point for ideas and plans. Here again, we see that familiar language. The intent is to provide homeowners a starting point for ideas for future projects. Just a list of ideas. Somebody's going to read that and, oh, it's just a list of ideas, we're good. But you got to hold on, you got to read that last sentence because that's the one that sticks. And then you also have to see electronic copies of the blueprints along with photo and video renderings are now available on the HOA website. And let's see, even the notification of the change of the blueprints are tucked in after a no news here sentence start of plans were shared at the meeting. Physical plans were shared at the meeting and electronic copies of the blueprints along with the photo renderings are now available on the HOA website. I feel like it's just, they're like trying to put it in there. They want to say they gave notice. This isn't notice. Even if it was really clear, it only went to, at most, about 51% of homes in an email. So they sent it to, at best, 51% of homes in an email and tucked it in to the 2nd page, I think it was the 4th paragraph. And besides just doing that, they worded it in a way that it has contradictory meanings and you have to pick which one. And because it's the last sentence, that's the controlling one. If people even read that far. I've been really watching them and I missed this the first time. Here's the letter closing. For any up-to-date information, register to the website for community information at hawthornhills.com. Sincerely, the Hawthorn Hills HOA Board. To register for that website, you have to request a password. And then you wait for the password. And it might be a while before you get it. It might be a day. And then you get the password, and then you can log in, but I think you only have a certain amount of time before you can do it before it expires. But even when you're on that website, there's not that much information on there. There's not the invoices we need. There's not bank statements. I've asked so many times what bank we use without being answered that it's kind of a joke, okay? Anyway, the recap is the board has blamed rumors and misinformation coming from the residents for confusion as to whether the paths are going in. Let's recap just the 10 things we've looked at here, just over the last year. They're all board communications or actions. At the end of the description, I'll put a check for on or X for off. Here they are. You know what? I'm not going to read all of them. I'm just going to say, you know, one was the meeting minutes. One was on. Both said on and off. One thing said both on and off. The judge's holding should be off. That wasn't from the board. It was from the judge, but it's not been acknowledged or followed or honored. May 31st, the email said that the paths were off. And then later on in the email, he gave 4 more messages, 2 more that they were on, 2 more that they were off. That's a single communication with 5 different signals, okay? June 17th clearing was confirmed by multiple parties to the HOA. That's the path is on. July 5th email, 4 signals they were off. 4 statements that were in that email that seemed to imply they were off. 6, the July 21st clearing, there were 2 different, the resident yelled at me on the phone, the clearing is being done for the paths because it's what people wanted, hung up on me, and it was also confirmed solely to be ordered by the HOA. So that's 2 indications that the HOA ordered and it was on. Between July 21st and August 23rd, the in-person meeting with the resident, the president told the resident the paths were off. Just a list of ideas. On August 23rd, rumors and misinformation, really clear statement, the HHHA board has no plans to install any walking paths in our subdivision. That was not as hidden at all as the other message that was hidden that they're back on. The 9th instance was December 12th, the website update, shortly before that newsletter that had the hidden message they were back on. They uploaded all of the blueprints called landscape plans, not like building plans. And then December 22nd, the letter said that the 2 different messages in that paragraph indications that the paths were just a list of ideas, and then the final sentence was like, yeah, so it's always been planned that we're going to pick the paths back up once we fix the lights. So the final tally, considering just the most recent 10 messages over a single year, not even a full year yet, is 1, 2, 3, 4, 5, 6, 7, 8. 8 that the paths are on, and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 that the paths are off. 8 the paths are on, 12 the paths are off. And we're the ones at fault for there being confusion. All the confusion we have is caused by reading the board's communications. Although, to be fair, document 2 was a signal the paths should be off from the judge. Like when Joey said it's a moot point. Okay, sorry that was long. Again, I wish there weren't so many contradicting documents, so this wouldn't have been so long. I tried to go as fast as I could, and again, within certain emails, there were like 5 different messages that had to be decoded. Oh my gosh, residents should not have to be attorneys. They should not have to splice, and they should not have to, like, you know, thread the needle through to, like, read all the different things. When somebody writes a paragraph and there's 5 different contradicting things in that, most people aren't going to see them all separately, which is the way it was written to try to avoid accountability. We see it. We see the whole document. I'm not the only one that sees it. Sorry to disappoint you. I want to be as clear as possible, and that includes trying to untangle this last year's board communications. So there you go. Thanks for your time.